Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest. Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Mauryan Empire or whatever, bitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. Late evening U.S. people. Good night, good morning, good afternoon, good evening, whoever you are, wherever you are, whatever you're doing, etc., etc. I'm glad you're doing here. Sorry for to play the extra long introduction again, but I just needed a little bit of time to regroup myself. I don't know how many of you know, but I am feeling far less than optimal these days. The reason being, I mentioned it on the Unexplained stream I did with Danny on Direct and Flux last Wednesday. I was doing some exercises that I don't normally do. So a new thing that my trainer was having me do, and we pushed it a bit much, and I had developed a case of acute tendonitis in both of my feet. So yeah, it sort of feels like my right foot, I'm walking on a knife, like stabbing into my heel every time I take a step, and it feels like someone is driving a knife into the top of my left big toe. Pretty much 24/7. And so I'm on day 5. I being optimistic, I'm sure there's some improvement, but it's such a constant 24-hour pain that just vacillates between throbbing and piercing, stabbing pain that I don't know. It's a bit demoralizing. I'm not whining. I'm just letting you know if I seem a bit off my game today, that's why. I'm on crutches, doing my best, but I still gotta keep doing stuff. So the doctor says we're looking at about 2 weeks. Yay! If I got to put up another 10 days of this or so, I'm just gonna lose it. It's rough. I have this thing with my feet. I don't like my feet being uncomfortable. When my feet are uncomfortable, I'm just in a crap mood. I hate everything. I'm just really sensitive and edgy and just uncomfortable. Like wet feet, super cold feet, super hot feet. Just anything like shoes too small. It just drives me nuts. And so it's actually, it's really mentally exhausting, and that's why I was a little bit late. It took me, it's about 10, 15 steps from from my bed where I was laying with my leg raised up to here, it took me 6 minutes to walk from 15 normal steps. It was about 100 of my little shuffle steps from my bed to here. So I'm sitting here. I'm doing my best. If I mean, if there's, just so you know, I'd expect to do the full show. But if for some reason I just kind of hit a pain wall, I'll have to check out a little bit early and we'll pick it up where we left off. But I'm thinking we're good. Anyway, I'm not whining about it. I'm just letting you know if I seem a bit off my game, that's the reason why. So, all right, we had a great F at Friday stream last Friday. That was a lot of fun. We had some of the most amazing women on the stream. We had a good time, and thank you to everybody that watched that and participated in that. We did on Danny on direct stream. We did an unexplained stream where we talked about space lasers and other technology, earthquake machines and things like that. So today we're going to be catching up on the last part of the first instance court's involvement in the Maya Kowalski case. Pretty much it's up to the appellate courts from here on out. I know I'm a little bit late to this game here. The orders came down like the day I had Greg Anderson on last week, which was fantastic and I loved it. That morning, like just right before I came on, a few hours before, a couple of orders came out, and I was going to talk to him about that, but I can't stay on the rails and he can't stay on the rails. I was like, oh my God, what are we going to talk about for 2 hours? We ended up just talking for 3 hours. Didn't get to a single bit about the orders. So good. That means I can go back and do it now. And also the final orders on the remaining issues. They came out a few days ago. I think, was it done on, did they come out on Friday? They came out on Friday. But that's what we're going to be doing today. Tomorrow, what is Tuesday? Like, yeah, my brain isn't functioning well. Tomorrow, Tuesday, we're going to be doing the Clayton Eckerd stuff. We're going to be looking at some of the evidence. We got some more motions. We've got a little bit of an explanation for Jane not showing up for court. We'll look at that. We'll look at some of the evidence that we haven't looked at yet. So that'll be tomorrow. Wednesday. Wednesday will be Zachariah Anderson Day. We're going to be doing an update on Zachariah Anderson. We're going to be reviewing the heretofore unseen interrogation tapes, the police interrogation tapes of Zachariah Anderson. We'll be breaking that down. Thursday is OJ Day, and Friday we're going to be looking at the Florida case of Aguilar Mendez, the 18-year-old Guatemalan boy that was roughed up by the cops. There's been a bond motion, and there might be a motion to dismiss filed at some point in the near future. So we'll see what we've got by Friday, and we'll bring up to date on some news. So that's what we've got coming up this week. And hey, everybody here in chat. Sorry I didn't take the time to say hi to everybody individually, but we have the usual crew here. We've got the Maya crew. Jules is here. Jules, you'd send me an email or a Twitter DM. It's thelegalvices@gmail.com or The Legal Vices on Twitter. You'd mentioned about coming on the stream once. I think we can make that happen. So reach out, get in touch with me, and let's see if we can make that happen. If that's still on the table. All right. I guess that's it. We've got 339 of you here and 169 likes. Hit the like button. Hit the subscribe button. You guys are always great with the subscribe button. Deeply, deeply appreciated. If this is your first time here, we're not always this slow getting going. I do apologize. Just kind of had to catch people up on the state of my ailments. We're under a good doctor's care. It'll take a couple of weeks for the tendons to settle down, and I'll be back on my game. But hopefully in the next few days, the pain will start. I don't care about it. I just want the pain to lessen. That's all. I can dish out pain like nobody's business, but I have one of the world's lowest pain thresholds. Okay, we've got our daily like and subscribe poll set up here. So take that like and subscribe poll after, of course, you hit like and subscribe. It's a simple poll today. The like and subscribe and vote poll is: what are you hoping to hear from the final group of orders? Something about Dracula, something about Nuremberg, palpable, or an island of hair. Those are what we're looking for. Let's choose which one you hope to hear. I don't know what's going to happen. I don't know if any of those are present, but I hope they are. Just any one of them. Choose which one you hope out of that list. That's all I could think of. So, all right. We're going to have to start the main program here. The first thing I want to look at is the... Oh, this is interesting. Oh, there it is. No, that's me. There we go. Hey. Oh, great. Sorry, both of my screens. But usually right around the 10-minute mark after starting up the StreamYard, like both of my screens will temporarily go blank. Used to freak me out. Now I'm just kind of expecting it, and I just have to roll with it. So that was that minor surprised pause there. All right, let me resize this. Let's see how we're gonna do here for the window. We don't want to see me that much. There we go. We'll do that. Embiggen this a little bit. Why is that so small? That's what she said. There. We'll do that. No, we don't want that. Sorry. All right, I'll just put me back in my normal little tiny place where I go. There. That way we can get this. It's such a pain in the ass to... They don't have like a full screen mode on stupid Adobe. All right. That's about as big as it's gonna get. Right. So, folks, what we're looking at here is the order denying defendant JHACH's motion for a new trial based on alleged juror misconduct. I know this is old news, but I wanted to go through it because I think it's interesting to see what the judge had to say about this, and I want to share my thoughts on what the judge had to say. This is finally where the judge gets a chance to say what he's always wanted to say, but he couldn't. But now that there's been a jury find, just about to close the studio. That would suck. This is where the judge gets to say. He couldn't before because the case hadn't been concluded yet. But now that the jury has come back in favor of Maya Kowalski, they've rendered their verdict. Now's when the judge can say, okay, the finder of fact has found these facts, and we can assume they're true. And now he can talk about them in a little more pointedly than he could during the course of the trial. So let's look at the judge. What did the judge have to say? Order denying defendant JHACH's motion for a new trial based on alleged juror misconduct. Well, yeah, Renee, yeah, we know it's denied. We know that. Denied. Before the court, following hearing and juror interview, is defendant Johns Hopkins All Children's Hospital motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. JHACH supplemented this motion 3 separate times in writing. Right off the bat, the judges, to me, that's a little bit of a dig in the side of JHACH's lawyers. He didn't have to say they supplemented the motion 3 separate times in writing, but he did. So that tells me that signals a little bit of annoyance on the judge's part to me. Reddit, hey, Reddit people, if you're here, hi. Reddit's been kind of quiet. They haven't really updated anything recently. Right. So they did this 3 separate times. Plaintiff responded in opposition on December 15th, 2023. The court conducted a non-evidentiary hearing on the motion on January 3rd, 2024. The court conducted a juror interview of juror number 1. Because JHACH failed to demonstrate any juror misconduct, the court denies the motion. It's just right there. It doesn't get any simpler than that sentence. And everything we need to know, the next 6 pages are just superfluous. That tells us everything we need to know right there. JHACH failed to demonstrate any juror misconduct, so the court denies the motion. Procedural history. All right. Now, he's already mentioned that the JHACH supplemented the motion 3 separate times. So now they're going to go over the history again, and I assume he's going to raise these constant motions by. Well, I shouldn't assume. I've read it. I haven't read the final order we're going to be reading. I've read the first 2, so I'll stop pretending that I haven't. That's just intellectually dishonest. On September 14th, 2023, juror number 1 reported for jury service and received the oath as a prospective juror by the clerk. And again, that oath as a prospective juror is You're sworn in to tell the truth, answer the questions truthfully, et cetera, et cetera. So you're essentially sworn in at that time. You cannot lie at that point. So he was sworn in on September 14th. After both individual questioning and group questioning, juror number 1 was seated on the jury, which means both lawyers wanted him there. Both sets of lawyers wanted him there. On September 19th, 2023, the clerk administered the juror oath to juror number 1. Now he's officially sworn in as a juror, where they're sworn in to do all of those things and not do all of those other things that jurors can and cannot do. The same day, he was seated with the consent of the parties. Again, he was seated by consent of both lawyers. On November 9th, 2024, following the delivery of the verdict in the punitive damages phase, the court discharged the jury with the consent of the parties. JHACH raised in its motion and supplements many issues concerning juror number 1 that JHACH claimed demonstrated juror misconduct by juror number 1 during the trial. These allegations included juror number 1's alleged failure to abide by court's instructions. Well, on December 15th, 2023, the court conducted a hearing on the motion. They made all the assertions, about that we don't really need to go over again. They'll mention some of them here, but by order dated December 20th, 2023, the court allowed a limited juror interview on 4 different topics. Now, you remember that they wanted juror number 1, juror number 1's wife. They wanted they wanted all of their electronic equipment. They were probably, if they would have got those, they probably were going to push for other jurors, possibly jewels. But the judge just kind of shut that down real quick. Like, nobody, you get juror number 1, you get about 4 or 5 different questions, and that's all you're going to get. So the court set that juror interview for Wednesday, January 3rd. Okay, the court determined that other requested bases for juror interview were either untimely, meritless, or both. Yes, untimely and meritless. You're late, and it ain't got a damn thing to do with anything. The court set the juror interview for Wednesday, January 3rd, 2024. On Friday, December 29, 2023, after 3 p.m. That right there that's judge speak for you mother effers. On a Friday night, less than an hour before I'm supposed to go home for the New Year's weekend, for the New Year's holiday, you mother effers file a motion. He didn't have to mention the time. He didn't have to mention it was a Friday. Notice the other times. January 15th, December 20th. What day of the week are these? We have no idea. What time were they filed? We don't know. The fact that the judge put this here on Friday, December 29th, after 3 p.m., JHACH files its motion for reconsideration of the scope of the juror interview. Now, mind you, the next day the court's in session, they're supposed to do this. That's a pissed off judge. Jules says, where are we at here? Jules says, Judge vindicated me without actually using my name. I respect JC for doing that. And Alan Walsh, I brought yours up just because my eyesight isn't great because I'm squinting. But you had 0 snow here. It's like the middle of summer. I hope you don't have snow there. All right. Oh, never mind. Sorry. Wrong Alan. Sorry. I don't know how much snow you get up there. Sorry. I thought you were Australian, Alan. Okay, then I had to open my eyes again. Apologies. I should just stick to what I'm doing here. Right. Let's see. What's up, Piggy? The dogs are walking around my feet. Okay, I do have to warn you about this. The dogs are walking around my feet. If one of them steps on either one of my feet, they did that the other day, and I was pretty surprised the neighbors didn't call the police. It was loud. So if I suddenly shriek in absolute pain, it's because a 50-pound dog stepped on my dead foot. All right, with that out of the way, let's get back to the motion. On Friday, December 29th, 2023, after 3 p.m., JHACH filed this motion for reconsideration of the scope of the jury interview. JHACH doubled down on its claims and affirmatively and prospectively alleged, without proof, that juror number 1 would lie during jury interview. JHACH confirmed in this reconsideration motion that the 3 supplements were the result in part of investigations by pro-JHACH internet communities. On Tuesday, January 2nd, 2024, the first business day after JHACH filed its motion, the court entered its 14-page denial of reconsideration. Tuesday, January 2nd. The day before the trial, the first day back. So what that means is the judge and at least one, possibly more of his clerks spent their New Year's holiday looking at law and writing the stupid order. Judge can, and we've talked about this before. They filed their motions. JHACH filed their motions right before Thanksgiving, right before Christmas, and right before New Year's. So the judge has got to be pissed about that. There's no way he's not. The court declined to expand the scope of juror interview that was to occur the next day and further explained why the subjects not included in the juror interview were untimely or meritless or both. On January 3rd, 2024, the underside conducted the juror interview of juror number 1 in open court in the presence of the parties, media, and public spectators. Juror number 1 appeared with his attorney. The court questioned juror number 1 as to each of the 4 bases identified in the court's December 20 order. The court allowed the parties outside the presence of juror number 1 to suggest additional questions within these 4 topics. The court then asked juror number 1 some follow-up questions. The court details below the findings of each of the 4 topics. And before we get there, just want to say, hey, give a super shout out to Whiskey77, who has become our newest member. Thank you so much for joining the Clean and Sober crew. Very, very much appreciated. Thank you so much, Whiskey77, for the support. So you know, there's no other membership stuff or any other things there. We'll read them if they come up. Alan Walsh says, I would have denied it if they sent it to me on New Year's Eve. That would be improper, but it would certainly be understandable. If they just, all right, just out of spite, I don't care if it is good law and they are good legal arguments, I'm dismissing it because it's New Year's Eve. Yeah, that would be wrong. But it would be understandable. All right, the 2002 case. This is one of the things they brought up. JHACH contended that a 2002 circuit court case from the 17th Judicial Circuit in Broward County revealed a reference to child abuse and DCF. This was concerning to JHACH because the subject matter of the current lawsuit included discussion of DCF's actions in sheltering Maya Kowalski, based on a claim of medical child abuse. JHACH points to juror number 1's no responses to the supplemental questionnaire when asked if juror number 1 had any close friends or family members with a child sheltered into protective custody, or if juror number 1 had any strong opinions concerning DCF's ability to take children into protective custody. Well, the court received into evidence the 2002 docket during the court juror interview. The public docket in that case reveals the case was an interpersonal violence petition filed by juror number 1's then wife against juror number 1. Juror number 1's then wife failed to appear at the return hearing, and the petition was dismissed with no adjudication on the merits less than 2 weeks after it was filed. So there was no case in which the DCF was involved. There was no, what was the criteria here? Any friends or close family members were a child sheltered into protective custody. It wasn't there. None of this happened. During the court's questioning of juror number 1 credibly confirmed that there was no involvement by DCF during that 2002 case. And juror number 1's then minor children were not taken into protective custody by DCF or otherwise sheltered. Juror number 1 also credibly explained that when he filled out the supplemental juror questioning in the current case on September 14th, 2023, that he had no opinion whatsoever of DCF or the government's ability to shelter a child. There is no evidence that any of juror number 1's answers to the supplemental questionnaire regarding DCF were incorrect. There is no evidence that any of juror number 1's answers. If you're going to start making, JHACH's lawyers might want to take note of this in the future. If you're going to make allegations, if you're going to make these motions, especially if you're going to make them at the last second over a major holiday like New Year's, you're going to want to bring some evidence. Your theories, your hypotheses, your hopes, your desires, your speculation. That ain't good enough to get your order through. That ain't good enough to get the court to rule in your favor. And they knew this. They knew this. Jules says Shapiro just sat there with his head down the entire time. I think he realizes now he should never have relied on the R group. Made him look like an idiot. Yeah, he was really, really interested in his computer screen during that entire hearing. And it was like the older lawyers on his team said, all right, okay, Junior, you messed this up. Let the adults talk now, okay? You just sit there and play Tetris or Minecraft or whatever. Let the adults talk. The 2002 Broward case came from more than 2 decades ago. Does not demonstrate any juror misconduct. Yeah, and most places, most jurisdictions will have their own rules that after a certain number of years, you just can't bring the old stuff up. I don't know what it is in Florida, but especially like in criminal cases, prior bad acts, things like that. Generally, you're not allowed to bring up things, 7, 10, 15, 17 years in the past because they're just too remote. Flux says Minecraft, lol. Hey, Flux. Good morning. All right. Issue number 2. Whether juror number 1's new attorney, should be new, N-E-W. Now, if you'll notice, there are quite a few typographical errors as we go through this. Ordinarily, you don't see them because ordinarily, I guess, they have enough time to go through it and proofread it. And what I'm guessing a lot of this is it was dictated. And the voice to text didn't catch everything correctly. But this is probably because it was being done in a hurry over a holiday weekend. Stupid JHACH. The supplemental juror questionnaire included, among other questions, 97 names of potential witnesses. The supplemental questionnaire instructed the potential jurors to answer yes or no for each of the 97 listed potential witnesses, whether the juror knew or thought the juror knew the potential witnesses. JHACH contends that juror number 1 improperly said no to question 74 on the supplemental juror questionnaire regarding knowledge or potential knowledge of potential witness Deborah Salisbury, Esquire. Ms. Salisbury represented Jack Kowalski for some portion of the dependency court proceedings. Ms. Salisbury never testified at trial. At present, in its written motion, JHACH reached its conclusion of alleged juror misconduct based on an unidentified 2007 domestic relationship proceeding filed in Sarasota County involving juror number 1's current wife. The written motion did not provide more detail. Did not provide more detail. We're gonna get to that in just a second. During oral argument on the motion, JHACH affirmatively represented. That means they swore that this happened. It wasn't a passive thing. It wasn't a they didn't respond to something. They affirmatively said. They definitely, most assuredly said to the court that Deborah Salisbury was juror number 1's wife's attorney for her divorce proceeding. And the same attorney that represented Mr. Kowalski in the dependency court proceeding. Now we're on page 3 here. Let's scroll up here. Now, if you go to a court docket, okay, maybe it's maybe it's down. Okay, it's down here. If you go to a court website, if you go to the docket, you can pull up the data about a case. One of the names of one of the people involved, or a case number. You can go and you can pull the records for that. And it will tell you, we should do that at some point in time. But basically, it'll tell you the name of the defendant, the name of the plaintiff, or whoever the parties are in the criminal proceedings. It will tell you the status, all of the hearing dates that have gone. Sometimes you get all of the documents. But one of the very first things you will always see at the very, very top of any court document is the identity of the parties that represent the clients. And this is what you'll see if you go to the website. You'll see lawyers for defendant Johns Hopkins All Children's Hospital, C. Howard Hunter, Chris William Altenburn. It'll look exactly like this. It might even have their bar numbers and whatnot. But that's what it'll look like. It'll give you a rundown of each party's lawyers, who is representing these. And what they're saying here on page 3 of the order is that the I believe it was actually Shapiro himself that made the affirmative declaration that juror number one, where was it that Salisbury was juror number one's wife's attorney for the divorce proceedings. Prior to the jury interview, Deborah Salisbury filed an affidavit in which she asserted JHACH's allegations were false. It wasn't so much, I mean, assertion is being very generous. It was to the defense. It was pretty much a very, very bold statement saying that she absolutely was not, and that JHACH's lawyers were intentionally lying to the court. I believe she used the magnanimous word misleading, intentionally misleading, or intentionally misstating or something. Basically, she was just saying they lied and they knew it, that she had nothing to do with either juror number one or his wife during that old case. So she filed an affidavit in which she asserted JHACH's allegations were false. Ms. Salisbury stated that she never represented juror number one's current wife in any capacity whatsoever. She advised the court docket from juror number one's current wife's 2005 divorce proceedings from her former spouse demonstrates on the face of that docket that both parties in the case were self-represented litigants. In other words, neither party had an attorney in the divorce proceedings, and that it is an objective fact easily discernible from the docket of that dissolution of marriage case. Ms. Salisbury attached the 2005 document to her affidavit, and the court concurs with Ms. Salisbury's observation concerning this objective fact. So yeah, they're saying the judge repeating this objective fact is him agreeing with Salisbury that JHACH are liars, and they're intentionally lying to the court, which I think has a very good possibility of biting them in the ass when it comes time for the sanctions. We'll have to know how the sanctions motions are going to proceed in about a week from now, I think, is the deadline for deciding what they want to do. So we'll definitely keep you posted on that. But yeah, this is the judge saying you could have looked at this. Same thing that Maya Kowalski's lawyers said in their response to this. All they had to do was go to the court's website, where we get all of these documents, where I get them, where Rob gets them, where Megan gets them. We all go to the same place. We go to the court's website. All you have to do is go there, and it tells you. All they had to do was go there, hit the case name, and they would have known that she didn't represent either one of them. So that was, I don't know if that was a Reddit thing, but if it was a huge mistake on the part of the lawyers to believe something like that without questioning it. And if it didn't come from Reddit, it was an even bigger F up to say something patently false when that is the easiest of the things that they have alleged to prove. That is the easiest thing that they accused juror number one of for them to prove. So it does not look good for them. They need heavy sanctions. I seriously hope that they get sanctioned to ridiculous amounts. We'll have to see how that plays out. Let's see. Okay, Ms. Salisbury further stated in that 2007 she was appointed by a family law judge to represent an individual in a 2000 domestic relation proceeding. Ms. Salisbury discussed in her affidavit that she attended a brief hearing in that 2007 case where juror number one's current wife may have been present. Ms. Salisbury's role in that proceeding was not to represent juror number one's current wife. Instead, her representation was adverse to juror number one's current wife. She was on the other side of juror number one's wife. She didn't represent juror number one's wife. In the current case, JHACH has done nothing to clarify its position with respect to Attorney Salisbury. And that this next three words, retract any representation. That goes back to Salisbury saying it was an intentionally misleading statement, to the judge saying they could have easily checked it out, and he seems to know it was an intentionally false statement. So it has done nothing to retract any representation. If there are any sanctions coming down in relation to this particular issue, I think that's going to be the crux right there. That they didn't go, oh my God, we made a mistake. Oh, there was a horrible typo, or oh my God, we shouldn't have. Oh yeah, we Mea culpa, mea culpa. We completely withdraw this entire argument. The court is saying you knew it was intentionally false. You intentionally lied to this court, and you took no remedial measures to retract any of that representation. I think this might come back to bite them in the ass hard, that they did not completely retract it, find whatever excuse they could find. Even, I mean, the courts tend to be kind of lenient on things if you at least show a modicum of remorse, regret, and and chagrin and shame for doing this. But there was nothing, and the court pointed this out, that there was nothing. There was no retraction of any representation or no dispute of Attorney Salisbury's affidavit. I mean, how are they going to refute it after what she said? There's no way for them to refute it. They should have gone back and retracted it as loudly and as apologetically as they could, but they didn't. During the juror interview, juror number 1 testified he and his current wife married in 2016. He also testified credibly, because he had it tattooed on his arm. He also testified credibly that on September 14th, 2023, when he filled out the supplemental juror questionnaire, he did not know attorney Deborah Salisbury. There is no evidence juror number 1 even knew his current wife in 2007. I like that last statement. They didn't even show that he knew his wife back then. So how could he know the lawyer? JHACH's claim that juror number 1 knew Ms. Salisbury is meritless. There is no evidence of juror misconduct on this issue. Those are some pretty straightforward, pretty bold statements there. They've been crushed on 2 of the 4 issues they brought up. Jeff Hayes says, just curious, even if there are no sanctions, can this filing be used in another case against JHACH's attorneys as to the credibility of the arguments made? No, they wouldn't be able to bring this up in another case involving the lawyers. It would be isolated to this case. I mean, even if they get some sort of reprimand from it, you can't bring up in trial the fact that the other lawyer was reprimanded for doing something stupid. So yeah, but I mean, the world is going to know about this. Uh-oh, Alan Walsh is being filtered. Never filter a Scotsman. They get angry. What's being filtered, Alan? All right, we've currently got 628 people and 322 likes. That means 300 of you, half of you haven't done your job. Just real quick, pop on down there and hit that like button. And if there's even one of you 625 people that have not yet hit the subscribe button, do it. I'm here in excruciating pain. Acute tendinitis ripping through both of my feet. Every move is anguish. I sweat walking from one room to the other. I hobble like something that hobbles. I can't even think fast enough. The least you can do is hit that subscribe button to thank me for my efforts here on my deathbed. Okay, that may have been a little exaggerated. Well, I mean, the pain aspect of it wasn't, but I mean, I'm not a sympathy guy. But please, no, just joking. Everybody, please, I would appreciate it though if you would subscribe. Hit that subscribe button and keep us going in the right direction. We're about 100 away from 67,000 subscribers. So that would be awesome if somehow today we got to 67,000 subscribers. That would make me just the happiest chipmunk in the tree. So do that. And how are we doing on our poll so far? All right, our like and subscribe poll is, what are you hoping to hear from the final group of orders? 35% of you say you're hoping to hear about Dracula. 18% of you say you're hoping to hear about Nuremberg. 18% of you also are hoping to hear the word palpable. And 29% are hoping for a reference to an island of hair. All right, that's some good odds. Let's see how it goes. We'll if I miss one of these words of the day, we need to do that. We need to do like a Pee-wee's Playhouse word of the day thing. That's what we need to do. All right. All right, so here let's move on to no, we're not moving on yet because we have our very first super chat of the evening. Thank you so much to Nancy Joe M. Thank you so much for the support. Thank you so much for the $10 super chat. I'm no expert, but it seems JHACH behaves in a way that they think they're untouchable. How much can the John Hopkins name protect them? It just feels arrogant to me. Well, see, that should tell you how little JHACH actually cares about this judgment. again, it's their insurers are the ones that have to pay out the ass. Johns Hopkins, they're 50 mil out of pocket at worst. But this team of dedicated lawyers on JHACH's defense team in so many other cases they've handled have saved JHACH way more than $50 million. So this is exactly the kind of lawyer they want. They're untouchable to JHACH. JHACH would keep, I can't imagine what it would take for them to get rid of these senior lawyers. It's a crappy thing to do, but that is their job, is to save JHACH money. And they've saved, I can guarantee you, they've saved JHACH way more than $50 million over the case of their careers working for JHACH, and will do so in the future. So this is just kind of a little speed bump for them. It just feels arrogant. Oh, it is arrogant because they are. That's why it feels arrogant, because they are, and it is. It's shitty, arrogant behavior. See, Jules, JHACH needs to fire this law firm when it's all said and done. I would almost guarantee they're going to get a raise coming out of this. I know it sounds ridiculous, but it shows to JHACH that they're willing to fight. They're willing to do whatever it takes to try to save JHACH money, even skirting ethics rules, even doing things like intentionally lying to the court. They're willing to go that far to protect JHACH and save JHACH's money. I think they're going to get a big old pat on the head from JHACH out of this. Jules, saving the money versus reputation, which means more? I'll give you two guesses, and your first one doesn't count. Money. Jules, you're thinking like a rational, decent human being. You're not thinking about big pharma, big medical bulldog lawyer. It makes no sense, because you're a nice, kind, rational human being. You got to think like a scumbag hospital and scumbag lawyers. Then you can kind of see it. It's all about the dineros. Thank you so much, Nancy Joe M, for that super chat. Thanks for kicking that off. Our first super chat of the evening. Don't let it be the last. All right. Issue number 3. Whether juror number 1 spoke with his wife about the case during trial. JHACH attached to its motion several internet postings made during the pendency of the trial about the trial JHACH attributed juror number 1's wife. And that was the whole gist of the motion. Basically, I'd say 80% of it was, this is what juror number 1's wife did. This is what juror number 1's wife said. And the other 25% probably was and their very, very best friend, Jules, sorry to bring up your name again, Jules, there was like this much about what juror number 1 himself did. It was all about, they had this great insider, Jules the insider. They had juror number 1's wife. They were sitting next to each other in court. They were talking to each other for a bit. And so therefore they must have talked to juror number 1, and it must have been improper. Ugh. It was stupid, and across the board, it's hard to get a group of lawyers to agree on anything, really. But across the law tube, lawyers on YouTube, spectrum, right across the entire arc, the entire pantheon of lawyers on YouTube, not a single one said, "Why, that sounds like a good argument." Quite literally, every lawyer that said anything about this said, this is idiotic. This is stupid. This is some of the worst stuff they've seen. The only one that came even slightly close, and it wasn't anywhere near JHACH's side of the argument, was probably Peter Tragos, the lawyer who said, if, speaking theoretically in a hypothetical world, if they can prove some of this, then there might be a problem. And that's still not even coming anywhere close to saying it was a good argument. So 100% of the lawyers across the board said, this is a stupid, bad argument. Oh, sure, Jules, I would love that. We'll do a deep dive of that in your show so you can have a real big picture of what actually happened. See, that's why I want to talk to Jules. So we can say, tell us all about the deeds you've done. Tell us all about the nefarious days, the notorious days of sitting in the courtroom, eating lunch, getting your picture taken. Tell us all about the evil that was done. Oh, Lord. Because there are a lot of people that have those questions. We'd love to have you on to talk about it. They couldn't prove it because it never happened, right? God, all right. Dun, dun, dun. We've highlighted the notorious she who must not be named. JHACH attached to his motion several internet postings made during the pendency of the trial about the trial that JHACH attributed to juror number one's wife. JHACH also attached a screen grab from the broadcast of the October 30th, 2023 trial day depicting juror number one's wife sitting next to an individual JHACH contends was pro-plaintiff and who appeared on various internet shows that were reporting on the trial. So stupid. Oh, JHACH. While JHACH contended that the contents of juror number one's wife's posting suggested there was communications between herself and juror number one concerning the trial, the court disagreed that those postings led to that conclusion. For instance, juror number one's wife posted prior to the testimony of Detective Graham that Leo, juror number one, would have questions for Detective Graham. As the court previously explained in open court, as the court previously told you to shut up about JHACH, but you completely ignored and continued to harp on it, anyone following the case knew juror number one was a retired law enforcement officer and that juror number one was asking questions of most witnesses. Yeah, and that's what we were all saying. This is right about the time I picked up the trial and was on Megan's channel as much as I could. This is right about where I picked it up, where a law enforcement officer we knew there was a law enforcement officer on the jury, and we knew there was a law enforcement officer taking the stand, and everyone in the entire internet, lawyer, spectator, true crime watcher, wine box, TV mom, everybody said, oh, this cop is going to ask some questions of that cop. It was a surprise to literally no one on planet Earth that was even tangentially attached or viewing this trial in any way, shape, or form. So, yeah. As the court previously explained in open court, anyone following the case knew juror number one was a retired law enforcement officer, and the juror number one was asking questions of most witnesses. Juror number one's habit of asking witnesses multiple questions was predictable, perhaps not as certain as death and taxes, but nearly certain, such as a traffic backup on I-4 near the Disney Champions Gate area. Okay, little bit of snark. There's the read between the lines snark we've been pointing out. This is a little bit of overt snark coming in through here. That's a little bit of snark. Yeah, we knew how predictable was it? Maybe not as predictable as death and taxes, but certainly as predictable as a traffic backup. Gotcha, bitch. An internet post suggesting juror number one would have questions for a witness, including law enforcement witnesses, did not fairly or remotely suggest discussion between juror number one and his spouse. There were other posts too that JHACH contended show communications, but in context of this case have innocent explanations and do not suggest inside knowledge. See, here's another problem. Here's another problem that you get with a lot of what happens on Reddit. I know Flux hates the word conspiracy theorist, but we're going to be using that word anyway. You get all these conspiracy theories where they'll take one little piece of information, disconnected, disjointed, and unrelated to anything else, and they'll twist it into the most nefarious weird. They'll twist it into what meaning they want to extract from it. Not what it actually means on the surface, not on its face, or what a normal, rational thinking human being would think that those words meant. They'll say, okay, this is my worldview. This is what we want to think about juror number one and juror number one's wife. Oh, and there was this comment, there was this post, there was this picture. So we've got to twist it to fit there. And that's what happens when you listen to those people. you get statements like, yeah, every other thing they showed in the context of this case have innocent explanations and do not suggest inside knowledge or improper communications with juror number 1. Nothing about the content of those questions suggested to the court that juror number 1 was speaking to anyone, including his spouse, about the case. Regardless of the court's construction of those posts, though, the court allowed a juror interview on the topic. Okay, regardless of the court's construction of those posts, though, the court allowed a juror interview on the topic. The court directly questioned juror number 1 whether he had any conversations with anyone, specifically including his wife, about any matter associated with the trial. Juror number 1 credibly and forcefully testified that he did not have such conversations with anyone, including his wife. He also credibly rejected any suggestion that he communicated improperly with his wife, even non-verbally. Oh yeah, because they were saying there was like eye contact. You know, they were using like telepathy or some shit to communicate with each other. It was stupid. Ugh. There is no basis for the court to conclude either by the contents of the questions themselves or following the juror interview that juror number 1 had any improper communications about the trial with anyone, including his wife. This claim does not show juror misconduct. On to our final issue. Excuse me while I take a little sip of wine. Have a lovely little Spanish Rioja. Right. Whew. Hasbro needs to send JHACH and their lawyers Clue so they can get one. Nice. Issue number 4, the last. Whether juror number 1 obtained information about this case. Remember, he was supposed to be crawling around one of the obscure witnesses' website. I mean, not the witness wasn't obscure. He was the witness's obscure website where he stumbled across the term creature comforts. That JHACH's lawyers, again, affirmatively stated no one ever used that word in court. The only place juror number 1 could have found that was if he went to this witness's webpage, rooted around, and saw the word creature comforts. Except for it took about 8 minutes for you people in chat to go, well, wait a minute. This witness on this date, this timestamp said this using the word creature comforts. Again, people in chat on a live stream can go back and find it that fast. They didn't. Specifically, JHACH also contends they violated court's repeated instructions not to investigate or receive information about the case outside of the court. Specifically, JHACH contends that on October 9th, 2023, juror number 1 used the term creature comforts in a question to a witness. JHACH identified a screenshot reportedly by Dr. Anthony Kirkpatrick's website that contains the phrase creature comforts. Based on this happenstance, JHACH leapt to the conclusion, and we know what happens.
You see, it would be this mat that you would put on the floor and would have different conclusions written on it that you could jump to.
And that's what they did. They leaped to the conclusions that juror number 1 was performing an investigation outside the court. Plaintiff, in their response, observed that on September 28th, 2023, a witness in open court before the jury used the same creature comforts phrase. Given juror number 1's habit of taking copious notes and referring to them when formulating his juror questions, plaintiff posited that JHACH's theory is unsupported. Despite the innocuousness of this phrase and its common usage in our lexicon, the court permitted a juror interview on this topic. So again, he's saying, even though this is a common phrase, even though people use it frequently, we're going to let him, all right, we'll question juror number 1 on this just so you don't have something else to bitch about in your appeals. Again, the court questioned juror number 1 on whether he conducted any investigation outside of court. The court specifically asked juror number 1 if he either used the computer to review Dr. Kirkpatrick's website or whether he read the website even if someone else, such as his wife, left it visible for him to review. Juror number 1 again credibly testified that he did not investigate, and he further credibly testified that he did not seek out or review Dr. Kirkpatrick's website. There is no basis for the court to conclude that juror number 1 performed any out-of-court investigation, contrary to the court's explicit instructions not to. Having reviewed the motion and supplements, listened to oral arguments, and conducted a juror interview, the court finds juror number 1 did not violate any instructions or otherwise engage in any misconduct.
Gotcha, bitch.
JHACH has failed its burden to demonstrate any juror misconduct. Accordingly, the court denies JHACH's motion for a new trial based on alleged juror misconduct. Done. There we go. That one's out of the way. That's the first motion. You're not getting a new trial because of juror misconduct, because juror misconduct never happened. That is laid to rest. It is dead. It is gone. That particular beast has been killed. And let me pause my camera here for a second while I run the Kleenex over my nose. It's a little bit kind of running here. All right. Well, what are we on to next? Next, we're going to be looking at the order on post-trial motions. We're not going to read all of this because it's a lengthy 17-page document. We're going to stick mostly to the highlighted bits, maybe a little bit before, maybe a little bit after the highlights. Let's see, we don't have any super chats or monthly membership chats to read. So let's raise the issue one more time here at the halfway mark. 683 peeps, 429 likes. We've closed the like and concurrent viewer gap from 300 to 280 or 260. So everybody just get down here. We're gonna just kind of grift here for about 1 minute. During that 1 minute, just take a half a second and click that like button. Make sure you're subscribed. If you've subscribed before, just double check to make sure you're still subscribed. And if you haven't subscribed, do me the super solid. We're trying to get to 67,000 subscribers. We're how far away? Let's see exactly how far we are away from that right now. How far away from that are we right now? Yeah, no, we don't want that. Come back. Baby, come back. Let me go to my YouTube studio here real quick. Analytics say what? Oh, we are 102 subscribers away from 67,000. 102 subscribers. So we need to get 102 subscribers. That'd be awesome if we could do that like within this week. That would be super awesome. So if you haven't subscribed, I would appreciate it greatly if you would just do me that. It doesn't cost you anything. You don't even have to. You don't even have to come again to the channel. You can just click subscribe and just leave it there and never bother with it again. But I would appreciate that. All right, our like and subscribe poll. How has it changed? Oh, we've got a little bit of a shift in things here. For what words are you looking through? None of our words came up during the first order. We got 2 more orders to go. 35% of you say you're hoping to hear about Dracula. 19% of you are hoping to hear about Nuremberg. 17% of you are hoping to hear the word palpable. And 29% of you are hoping to hear a reference to an island of hair in a sea of forehead or whatever it was. All right. Nothing else to do here. Let's move on to the next portion. This next order. The order on post-trial motions. This is a powerful way to start. The judge didn't have to write this. And this pissed off the Redditors. He's writing his story. He's like, yeah. This is a judge trying desperately to say how disgusted and disappointed he is with JHACH's lawyers. Pain more intense than childbirth. Pain more intense than kidney stones. Pain more intense than amputating one's limb. The worst pain imaginable. The degree and intensity which most of us cannot comprehend. Pain so intolerable that the condition is nicknamed the suicide disease. This was but a small portion of the evidence presented to the jury concerning the pain associated with a condition called complex regional pain syndrome, CRPS. Ginger333 says, the island of hair is where Jeff's hair went on vacation and never came back. Oh, mine's a lifestyle choice. Mine's actually starting to grow back in. I haven't shaved in my head in a couple of weeks. But yeah, mine's a lifestyle choice. Well, I guess my missing hair is a lifestyle choice. His remaining hair is a lifestyle choice. I could grow back a full head of lovely hair anytime I wanted to. I just don't like it. All right. Maya Kowalski contended at trial that she has CRPS and had CRPS when she presented to Johns Hopkins All Children's Hospital on October 2016. JHACH disagreed that she had CRPS. And the jury was presented evidence that healthcare providers at JHACH believed she was faking it. And there was evidence that JHACH treated her, or more precisely, declined to treat her accordingly. Yeah, this isn't the first time you're going to hear the judge commenting this way about their lack of care or their lack of decency. I don't know what you want to call it, but yes, the evidence that JHACH treated her, or more precisely, declined to treat her accordingly. The jury learned this failure to treat CRPS will increase the number of severity of and duration of future CRPS flare-up episodes Maya will experience throughout her entire life. In other words, there was evidence that JHACH, by its conscious indifference, sentenced Maya to even more extreme, debilitating pain that she will have to endure throughout her life than she otherwise would have had JHACH correctly treated her. This is not how you want a judge to begin talking about damages if you're a JHACH. This does not bode well for the judge reducing your payouts substantially. Ugh. There can be no question the jury credited Maya Kowalski's version of the evidence, and the jury rejected JHACH's claims that it provided Maya with exceptional, compassionate, and heroic care. That was a little bit snarky. That was little sarcastic there on the judge's point. I like that. They're allowed. The jury rejected JHACH's claims that it provided Maya with exceptional compassion and heroic care. The jury rejected JHACH's belief that it was Maya's savior. I wonder if the savior was the capitalized savior, as in the savior of all mankind, Jesus, or if it was just supposed to be a lowercase savior. But I like the uppercase savior. Keeping the uppercase savior that way. The jury rejected JHACH's belief that it was Maya's Jesus. They threw the real Jesus in the dumpster. So yeah, they replaced Jesus as Maya's savior, the same way that Sally Smith was going to be replacing Beata as her mother. Ugh, what a horrible group of people. The jury found that JHACH on at least 3 separate occasions falsely imprisoned Maya Kowalski, and JHACH on at least 2 separate occasions battered Maya. The JHACH management knew about this intentional misconduct and directed it, condoned it, and ratified it. Brutal direct statements there. They directed it, they condoned it, and ratified it. JHACH's management ratified it. JHACH also intentionally inflicted emotional distress upon Maya. Yet, JHACH continues with its quest to immunize its conduct, even though that conduct does not remotely result from its call to the DCF abuse hotline or its participation in the dependency court proceeding. Oh, was it Beatty that wanted to be the mom? Beatty wanted to be the mom. Whatever. One of the 2 members of the 7th floor coven wanted to be your mother. Ugh. Beatty, Smith, whatever. They're just different manifestations of Satan. Horrible people. The jury also presented with evidence concerning JHACH's egregious treatment of Maya Kowalski's mother, Beata Kowalski. Based on that treatment, the jury found that JHACH intentionally inflicted emotional distress upon Beata Kowalski that resulted in her death by suicide. Well, that's the court's overview of what happened. And again, if you're JHACH and you're hoping that this judge is going to completely demolish the awards that were given to the Kowalskis by the jury, you don't want to hear what they just read. That does not bode well for you. By this point, they know they are intercoursed. There is no way they don't have any understanding that by this point, this order is going to just intercourse them right up the keister. Post-verdict, JHACH timely filed an omnibus 144-page motion entitled Renewed Motion for Directed Verdict, Motion for New Trial, and Motion for Remediator. Their words, you're going to call it the motion. The motion includes a 6-page table of contents. That's a little bit of snark from the judge saying this was way too effing long. Even the table of contents was 6 pages long. Found at pages 7 to 12 of the motion. As requested by the court, plaintiffs replied in an 89-page response. This order disposes of JHACH's motion. Well, it doesn't say how it's disposed of. Disposed of doesn't always mean it's just thrown in the dumpster like Jesus. It just means they dealt with it. This order deals with those motions, but the vast majority of them were trashed. Caligula says they are getting motioned in their ocean. Yeah, yes they are. Doesn't matter of fact. An overarching theme of JHACH's motion is that it did nothing wrong, and its actions were rather ordinary. It was ordinary. What they were doing was ordinary. The jury rejected that view of the evidence. In its motion, JHACH either ignores or minimizes ample evidence of its misconduct. And this is the court giving their own opinion rhetorically. They're not expecting an answer. This is just the judge's thinking. This is a parenthetical statement by the judge in response to them thinking their actions were ordinary. Having sat through the entire trial, the court rhetorically wonders what JHACH's definition would be of an extraordinary action. If what you were doing to that little girl was not extraordinary, what in God's name do you consider to be extraordinary? That's what the judge is wondering. There is no doubt that the various monetary awards by the jury are significant. But being large, though, does not necessarily mean they are excessive. In almost all cases here, they are not excessive. Where they are, the court has remitted the excessive jury award. So there we go. We know we're going to knock the award down a little bit at this point. But the court, the judge says not by much. Most of the awards were dead on, well within the bounds of reasonableness, but a few of them were a little bit too much, and so we're gonna knock those down. And so just because the court remitted a few jury awards doesn't follow that the entirety of the jury verdicts were improper or the product of passion. They were not. The reader should not lose focus that this case was qualitatively different than most other cases in terms of novel issues, the juxtaposition of a dependency court proceeding, immunities, the vast number of disputed evidence, and the parties' conduct in 2016 and 17, damages sought, disagreements between counsel, length of verdict form, consumption of judicial resources, just to name a few. That there are more than 4,100 docket entries is proof. For the most part, the court rejects without comment JHACH's contention for the reasons explained during the trial, as well as those cited by plaintiff in their response. The judge is saying, look, we talked about it in court. The plaintiffs, they talked about it in their motions. I don't need to talk about it again. Their arguments are so without merit that I don't have to address them again. We don't even have to bring them up. So the stuff that I'm not talking about below is just stuff we don't even need to talk about because it's already been talked about enough and we're not getting anything new out of this. JHACH's issues affecting all claims. In pages 29 to 45 of its motion raises 5 separate issues that JHACH contends affected the entire trial. The court disagrees. For the most part, the court rejects JHACH's contentions for the reasons explained during the trial, as well as those cited by plaintiffs in their response. The court writes on only 2 of JHACH's contentions. My ears are getting sweaty from these headphones. My condition is trash tonight. I got to take those off. All right. It's just weird not hearing myself. That goes all the way back to radio days when you always have to hear yourself, hear how you're sounding. So it's kind of weird that I'm not hearing myself right now. All right. So basically, so they presented all of these issues. We don't need to talk about any of them. We're only going to talk about 2. There's only 2 of all of these issues they raised that we really, really need to address. One is the scope of JHACH's immunity. Note here JHACH's downplaying of the evidence to suggest that its actions were benign, contrary to the jury's construction of JHACH's actions. So, they're saying our actions were harmless. We didn't do anything to harm her. We didn't do anything to hurt her. In fact, everything we did was either neutral or for her own good. Well, let's see how they phrased what happened to Maya. The court should have extended the immunity. Why? Because this included JHACH's decisions to place Maya in a video surveillance room to confirm whether her actions are consistent with CRPS or are instead consistent with a psychological problem that may have been caused or enhanced by her mother's behavior. No, when you go back and you read and you listen to the trial and you read the text messages and the emails and whatnot, she was specifically put in that room without notifying the parents for the specific purpose of proving she was lying about CRPS. There wasn't this benign, just to confirm whether that's bullshit. The jury knew it was bullshit and they called out the bullshit. As well as removing Maya's clothes, stripping her down, naked if you listen to her, taking her photographs, was done to document her skin condition before she left for court. So yeah, I like how there's a parenthetical statement saying parenthetically. Note they're downplaying to suggest their actions were benign, and the jury found they were most definitely not benign. Bernice, they essayed that poor child. Yeah, it wasn't just they essayed that child. No question about it. JHACH has no explanation why, if these actions were taken for medical reasons, that was their deal. Everything they did, the monitoring, the taking of the photographs, it was all for the medical treatment purposes. Well, if these were taken for medical reasons, Maya's medical records are why, if they're taken for medical reasons, Maya's records are not littered with reports, observations, photographs, and other contemporaneous notes documenting what was being done to Maya and the results of those tests. So yeah, okay, and this was brought up in the motions, it was brought up in trial. Like, if this is being done for medical reasons, why aren't there any medical records about these events? Ugh. This makes my skin crawl. Literally, it just gives me goosebumps. They're just fucking monsters. All right. Certainly, the jury was presented with evidence and the lack of medical records explaining the necessity to place a commode just outside of Maya's reach and then intentionally delaying in coming to help her use the restroom, causing her to defecate on herself. If stripping a child and taking the photographs was done for medical reasons, where is the current medical record evidence? These are but a few of the cruel acts for which JHACH seeks immunity. This is a judge getting pissed. This is an angry judge right now. We don't always see a judge say things like, if stripping a child and taking photographs was done for medical reasons, where are the goddamn medical records? And then calling them cruel acts. Despite the court's trepidation during trial, and the court believes the trial transcript will demonstrate, the court routinely allowed JHACH to provide substantial and likely cumulative evidence, that means way too much repetitive evidence that and testimony concerning JHACH's theory that Beata Kowalski suffered from Munchausen syndrome by proxy. So they're basically, we heard a lot of evidence about this, this Munchausen by proxy, probably too much evidence about this. I probably let this go on too long because it gave context to how Maya Kowalski presented to JHACH on October 2016, and it had some probative value on the wrongful death and survivor claims. Plaintiffs objected to the court allowing this to the point where plaintiffs often complained JHACH was using Chapter 39 both as a sword and as shield. The court also suspects the transcript will confirm the court excluded much more of plaintiff's efforts to present Chapter 39 materials than the court excluded from JHACH's request. This is the judge again saying, yeah, we were probably a lot harder on the plaintiffs than we were on JHACH. Well, here's a few truths. After all is said, though, even under JHACH's requested more generous scope of immunity request, the reality remains. Here's the reality that remains. JHACH battered Maya Kowalski on at least 2 separate occasions, which actions do not otherwise result from any Chapter 39 action JHACH took. Let's rephrase that. JHACH battered Maya Kowalski on at least 2 separate occasions, which had nothing to do with their immunity. JHACH falsely imprisoned Maya Kowalski on 3 separate occasions, which actions had nothing to do with JHACH immunity. JHACH intentionally inflicted emotional distress on Maya Kowalski, which actions had nothing to do with their immunity. JHACH intentionally inflicted emotional distress on Beata Kowalski, which actions had nothing to do with their immunity. JHACH submitted fraudulent bills, which actions had nothing to do with their immunity. JHACH committed medical malpractice on Maya Kowalski, which action had nothing to do with JHACH's immunity. Consistent with its "we're protecting the mandatory reporter" theme, JHACH continues in the motion with its "sky is falling" public policy argument. When someone calls your argument a "sky is falling" public policy argument, they're telling you it's a bunch of shit. It's just a crock of crap. The sky is falling public policy argument, which is more appropriate for the legislature. If this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody in its facility once the child is ready to be discharged to foster care. And I love what the judge did here. The judge goes on in the next sentence to debunk that with one sentence. It's like, oh yeah, if this is allowed to happen, then no hospital will ever keep children longer than they absolutely have to with the DCF orders. The court does not understand JHACH's embrace of that public policy argument without reference to its egregious conduct this jury found JHACH committed. The judge is shooting that down by saying, well, when you're worried about whether or not people are going to whether hospitals are going to want to take in these children longer than DCF, you have to remember other hospitals aren't committing these atrocities on children. Maybe nobody wants to stay at your fucking hospital because you're doing these horrible things to them. They're going to go to other hospitals and maybe they'll stay at these other hospitals where you're not doing this. He's saying, yeah, you make this public policy argument, but you're not looking at your own issues, your own responsibility in that public policy argument equation. So the court denies JHACH's request to expand the scope of immunity. Just shut it down. Nope, we're not going to expand your immunity. Sorry, ain't going to happen. The addition of time. This is such a non-issue. This is such a non-issue that I'm actually surprised that the judge talked about this. Everybody gets their own amount of side. They raised one side asked for more. He gave them both the same amount of time, and eventually, eventually, JHACH's lawyers got everything they asked for plus a little bit more. They didn't use all their time, so the court cannot agree that JHACH was prejudiced because the case went to the last day the court announced the prospective jurors in September. During trial, the court allowed day off requests by the parties and allowed the jury to leave early on other days based in part on how the trial was progressing. Now, you also want to remember that one of the things that they were bitching about, Shapiro was bitching about his vacation. He didn't want to be there longer to present evidence. He wanted to go on his freaking vacation. That's what he wanted. So, oh yeah, this time it was the last day of trial. We didn't get. If they would have wanted it, they would have got more time. The court's granting this extra time did not adversely impact JHACH, especially when the court gave JHACH additional time and allowed JHACH to recall any person they felt they needed to further question. Further, the court believes the trial transcript will not reveal JHACH contending that they are unable to present substantial evidence that it wished to be presented due to a lack of time. Yeah. Rare in history says, I worked for a hospital for 12 years and worked closely with social services, discharge planning, and I was in quality and patient safety. JHACH went against all the rules. I'm appalled by them. Well, the jury was appalled by them too, to the tone of $261 million. So good on you for sharing that with us. Maya Kowalski's intentional tort claims. JHACH amalgamates all damages for all claimants for all. Okay, basically they're saying like JHACH, they just said this is how much money for all damages for all claimants, all related claims into a single number without regard to the separate conduct occurring at separate times in separate counts. They just asked for an umbrella amount. They didn't consider that each specific intentional act is its own separate, distinct claim, and each separate, distinct claim carries its own separate, distinct monetary value for actual damages and for punitive damages. JHACH didn't make any arguments in that regard. They were fucking stupid for doing that. They were ludicrous for doing that. It wasn't a single act. It was many, many acts, and they intercoursed themselves with that. By commingling multiple claimants' awards for multiple claims ignores the jury's specific awards by claim and claimant. Here's all of their claims. The punitive damages award do not exceed the statutory caps, even though the jury made findings to permit them to be exceeded. So they're saying that there are these caps that punitive damages can't go above in most cases. Think, okay, these caps, the jury didn't award beyond the cap, so just right there they're acceptable. But the court here says, based on the findings the jury made, they could have exceeded the normal statutory caps. There was findings that aggravated to the point where they could ignore the statutory caps and awarded much more, even though they awarded much less. Given the balance sheet and other evidence of net worth exceeding $1.2 billion introduced into evidence, the punitive damage awards were rather tempered between the need to punish and the consequences on others based on that punishment. If this jury truly were influenced by improper emotion instead of a dispassionate evaluation of the evidence, it could have awarded $500 million or more without coming close to bankrupting JHACH. Because that's really what you have to, punitive damages are to punish but not destroy. Punish but not bankrupt. So they could have made a finding of $500 million and not come close to bankrupting JHACH. But it did not. Instead, it awarded a meaningful but not debilitating amount. As it relates to the false imprisonment claim between 1018 and 1020, JHACH states with respect to the EEG room used by JHACH, the room had the capability to allow the EEG testing, which played no role in this case. The evidence at trial demonstrated that it played a vital role. So JHACH says it didn't play any case, but they're saying, no, it played a vital role in this case. Recall, there was evidence, among other evidence, that JHACH purposefully moved a portable commode just out of Maya's reach, and then intentionally declined to help Maya in a timely fashion, causing her to defecate on herself. And there were more similar egregious evidence at trial as to this claim. That's the second time he's brought that up. He's not happy about that. Confusingly, JHACH contends that this process was not actually treatment of Maya, it was preliminarily a non-invasive diagnostic test. This was a running problem for JHACH during the trial. Either it was performing a medical procedure or it was not. And JHACH was never clear and definitive with that quandary to the jury. So yeah, you have to say you were either conducting a medical treatment or not. They didn't say. They kept vacillating back and forth. And JHACH was never clear and definitive with that quandary to the jury. If it were a medical procedure, there should have been copious contemporaneous discussions about it in Maya's medical chart. The jury heard and saw evidence that there was not. And while JHACH says there is evidence she was not imprisoned in the EEG room, where, as here, there is disputed evidence, it is up to the jury to resolve the conflict. And the jury resolved the conflict as it relates to the battery, finding for hugs, kisses, and petting. No means no. The court, though, pauses to note at paragraph 81 of the motion of JHACH's discussion of battery, JHACH asserts, Maya Kowalski claims that Ms. Beatty told her that she wanted to be her mother. Assuming that testimony is true and Ms. Beatty's testimony is false, that statement is not a battery, and it did not involve a touching. It would have to rise to the level of extreme emotional distress even to be relevant in this case. Well, this, of course, minimizes Maya's testimony, which speaks to the intentional infliction of emotional distress, yet JHACH discusses it in the ordinary context of battery, saying the statement is not a battery as if to dismiss the conduct in its entirety. The paragraph is an artful dodge of the evidence, because JHACH then ignores the evidence that JHACH purposefully was trying to emotionally alienate Maya from her mother. Was trying to purposefully emotionally alienate Maya from her mother. Telling Maya her mother was dangerous, telling Maya repeatedly that someone else was going to be her mother was wrong. And there was evidence from which the jury could find JHACH's hubris in engaging in conduct to Maya's face that JHACH purposefully designed to destroy Maya's relationship with her mother. Right? No means no. Imagine defending JHACH. Imagine that. And that's one thing that I've said repeatedly. It's one thing I brought up a few times with Greg Anderson last week. Imagine being that big of a soulless, heartless monster where you do all of these unethical, slimy, scumbag things that JHACH's lawyers did, and being able to pat yourself on the back and say, we did a good job. Writing those motions about juror number 1, writing all of these things about Maya and her family, saying these horrible, shitty things they were saying about them after the verdict. Imagine being that soulless. Imagining being that empty inside that you think you did a damn good thing and you're ready to do it again. Yeah. Medical malpractice. Dr. Sally Smith served in at least 2 separate capacities with respect to Maya Kowalski. First, she was on staff at JHACH and consulted on Maya Kowalski's case. And she was never on staff here. Yeah, she's listed on the staff. And the judge specifically says she's on staff. Second, she was at the same time the medical director of the Pinellas County Child Protection Team, and at certain but not all times, was performing her statutory role with respect to assisting DCF with this dependency action. There's the representative of the estate. I think we skipped most of the rest of it. The jury's non-economic damage award due to Beata Kowalski's death. The jury awarded Jack Kowalski $50 million in non-economic damages for Beata Kowalski's death. The jury also awarded $18 million in non-economic damages. The total non-economic damage award for Beata Kowalski's death was $86 million. Smopo Vienna, you are here. Hey, Smopo Vienna, welcome. Good to see you here. I have an unboxing to do with Smopo Vienna, so we can do that. Stick around to the end if you want. We'll do your unboxing. Hey, thanks for making that known. We've been waiting for Smopo Vienna to make an appearance so we can do an unboxing. So we'll do that about 30 minutes from now or a little bit later. Right. So they got $86 million. The court concludes that no remitter is required. That seems like a really good number. Don't need to change that. The question of how to compensate a claimant for a human, non-economic loss always comes down to a question of money. See, and that's the thing. It always comes down to a question of money. It's not right. It solves nothing. It doesn't make anything better. You know, giving $260 million isn't going to bring Beata back. And I would guess that they would rather have mom than the money. That ain't going to happen. So that's one of the things that's one of the horrible things that happens in law. We just have to go to all of these human factors. Losing your mother, being tortured by the hospital. None of it is going to make you any better or restore you to where you were before you went in the hospital. But we have to put a dollar value on it. And that's what he's talking about here doing. The question of how to compensate a claimant for a human, non-economic loss always comes down to a question of money. The court expects any claimant would say they would rather have the decedent alive and with them instead of X or Y dollars, of course. The court concludes that the jury could properly award $18 million to each child and will deny the remitter motion for those claims. The $50 million award to Jack Kowalski for non-economic damages, however, is excessive. Here, the highest amount the jury could have properly awarded as a non-economic damage award for Jack Kowalski loss is $24 million in consideration of the evidence. So therefore, they'll remit the $50 million verdict for Jack Kowalski survivor by 26 to 24 million. In total, the non-economic damage award for the 3 remaining Kowalski survivors is 60 million. So it went down, 24 million? Was it 26 million, 24 million? The jury's economic damage award due to Beata Kowalski's death. The jury awarded Jack Kowalski 18 million in economic damage for Beata Kowalski's death. The jury also awarded each child $2 million. In economic damages, the jury also awarded the estate $653,676 in damages, and the total economic damage awards for Beata Kowalski's death is $22.6 million. The evidence of Beata Kowalski's economic contribution after consumption. So this way, I have to say, okay, how much would Beata Kowalski have? Again, this is a standard calculation that you do in personal injury cases and things like that. You literally say, okay, the person that died, how much would they have contributed to the family's earnings over the remainder of their workable period until retirement? And from that, you deduct an estimate of how much of that money the person themselves would have consumed as they go. The standard practice in Korea is the loss of earnings from the time of the accident until they retire, which is usually age 65. And then you deduct 1/3 off the top for the theoretical amount that the deceased would have consumed of their own earnings over their life. That's kind of what he's talking about here. So the evidence of Beata Kowalski's economic contribution after consumption, together with her services provided to the survivors, cannot support $22.7 million. So he's basically saying she wouldn't have contributed $22.7 million to the family over the course of her life. And it would be somewhere in the low $6 million range in the aggregate, which is almost the same maximum JHACH suggested. So they're saying she probably would have been around the $6 million value. The court will remit the $18 million verdict by $16 million to 2, and the $2 million to $1.75 million for Maya and Kyle, $250 million by 250. Yeah, 250,000 million, 250,000 to 1.5 million. That kind of scared me there for a minute. So they took off 250,000 from each of the kids and 16 million from Jack's order. The billing fraud. This is the one I expected them to just gut. The jury notes in other counts awarded Jack Kowalski is a little more than 1.5 million in economic damages associated with Maya's care. Question 32 and 33 on the verdict, the jury awarded Jack Kowalski $3 million and $2 million respectively for various economic damages. Of all the issues in this case, the party spent the least amount of time and attention on this claim. So will the court. And this is exactly what I thought would happen. They remitted the $3 million to $1 and remitted the $2 million to $1. That's exactly what I thought would happen. They would just throw out. They can't throw it out entirely because the jury found they were damaged. So they gave them the least possible amount of damages for the billing fraud, which is $1 each. So yeah, that went from $5 million to $2. Absolutely expected. So that's the award. That's how it all came down. So essentially, what it is the amount went from 260 million to like 210 million, somewhere right around there. If anybody has an exact figure off the top of your head, let me know, because they took about 50 million away from the award. So the judge remitted about $50 million. Said, yeah, there's about 50 million of this is excessive. But yeah, I mean, that may seem like a lot. You know, I'd be, oh my God, you took off $50 million. They still get 210 million. So yeah, the 50 million, not such a big deal. There's still 210 on the table. All right, let's see. No super chats, no monthly chats, nothing particular to look at here. All right, we got 780 of you here. Hi, 780 of you. We're glad you're here. We have one more motion to get through today. Hey, Nicholas, 214 mil. Thanks. Yeah. 214 million. So yeah, you know, oh my God, they that's so unfair. They got rid of $50 million. Well, there's still 214. So JKD Buck JHACH lost. Deal with it. Or what? No personal attacks in chat. Is somebody personally attacking chat? Someone chat attacking someone else. Whatever. Aha. Play nice, kids. Play nice. I see what's going on in chat.
Am I not the captain of this ship?
All right. Don't make me send you to your room. All right. I haven't been paying much attention to chat today. You know, I pay attention if there's like in the days there's more of the super chats because that keeps my attention focused over this. The parts I saw seem to be going okay. Now be nice to each other. It's nice to be nice to the nice. Okay. Well, we've got one more motion to get through. This is the big one. This is the final order. Chat fight. Now let's keep calm. Let's keep calm, everybody, and spend your efforts super chatting. All right, this is the final judgment. The final judgment. Once again, the final judgment. Now, from here, my understanding is the next step. This is it. This is done. The court of first instance. The district court here, the Division C Circuit Court, is done. It's now moving to the appeals court. This is the end, my friend. The final judgment. Right. Let's do it. Let me take another drink here. Yeah, no more tufts of justice. Boo. This matter was heard on plaintiff's 8th amended complaint between September 14th, 2023 and November 9, 2023. Between the jury's rendition of all verdicts and entry of this final judgment, Maya Kowalski obtained 18 years of age. The court restyled the case. So restyled means that, before it was Jack Kowalski is the representative of Maya. They're saying now she's over 18. She's over 18, so now her own name, Maya Kowalski, has been added here. It didn't used to say, her acting for herself. That's all that restyled means. She's now included officially acting for herself. She's acting on behalf of herself, making her own decisions because she's above 18. Nancy Korinsek. Sorry to stumble over your name there. I have a friend named Nancy Korenkowitz. I was trying not to say Korenkowitz. Super chat glitching. Screw you, Super Chat. What are you glitching for? I hope that's the truth and you're not just leaving me in the doghouse. All right, chat. Hey, chat. We have a Chandler sighting. We have a Chandler Remington sighting. We appear to have a Chandler Remington sighting. Didn't see her sneak in there. Hi, Chandler, if you're here. Oh, there you are. Hello, all. Hello, Chandler Remington. Good to see you here this morning. What does it matter what their name was? They were an agent of JHACH, and JHACH was being sued. I don't know what that's in reference to. What does it matter what their name was? They were an agent of JHACH. Are we talking about Sally Smith, or? I'm not sure what we're talking about. I'm not sure what we're talking about with that, but it doesn't matter. Everybody has their own names. All right, no more chat fight. Seriously. Don't be dicks. Between the jury's rendition of all verdict entries and this final judgment, Maya Kowalski has obtained 18 years of age. The court restyled the case. Damages awarded to Jack Kowalski as parent and next friend of Maya Kowalski on the verdict forms have been awarded to Maya Kowalski in this judgment. JHACH sought a new trial based on alleged juror misconduct. There was no juror misconduct, and the court rejected JHACH's claims. Island said for $2 is no doghouse, only happy chipmunks. I'm a happy chipmunk. I'm just a happy chipmunk with dead feet. A chatter wants to name the person who originally threatened they'd arrested them if they left with Maya. Okay, whatever. What's the point? All right. Well, I mean, what's the point of talking about that in the first place? Anyway, someone was claiming the false imprisonment wasn't valid because Jack can't remember the security guard's name. Well, you know what? It is valid because the jury said so. End of story. Go with God. That argument is invalid. Whoever made it, because the jury said that it was false imprisonment. So there you go. There's nothing you can do. The jury said it was false imprisonment. Therefore, whatever we happen to think, it was false imprisonment under the law. Dun, dun, dun.
Gotcha, bitch.
JHACH also filed an omnibus post-verdict motion seeking judgment notwithstanding the verdict, a new trial, and remittitor. The court mostly denied the motion, but granted remittitor as to a few claims. The plaintiff accepted the remittitor and elected not to have a new trial as to those few claims. Peggy, what are you doing? Peggy, hey, Peggy. Okay. She's chewing on a ball. Couldn't see what she was chewing on. It was freaking me out. Because the other day, when I thought she was chewing on a bone, she was crunching on a piece of plastic that's attached to my humidifier. So I was freaking out there for a second. Sorry. All right. The plaintiff accepted the remittitor and elected not to have a new trial as to those few claims. So that's an important thing. The plaintiffs accepted the remittitor and elected not to have a new trial as to those few claims. Maya Kowalski's side said, we got no problem with the $50 million reduction. None. Done. So the plaintiff has no problem with it. Based on the jury verdicts as remitted, as to claim 1A, false imprisonment, October 7th to October 13th, Maya Kowalski, the jury awarded Maya Kowalski $2.496 million. In economic damages subsequent to her obtaining the age of 18. The jury awarded her $3 million in non-economic damage. The jury also awarded Jack Kowalski individually $67,200 in economic damages associated with the expenses of hospitalization and medical, psychological, and nursing care and treatment for the benefit of Maya Kowalski in the past and through the date she reached the age of 18. Also, the jury found by clear and convincing evidence that punitive damages were warranted. Oh, see, by the way, if we go back here, see where the court says the jury awarded false imprisonment? The court found it was false imprisonment because the jury found it was false imprisonment. It was false imprisonment. Sorry if you disagree with it. Sucks to be you if you disagree with it, because that's what the jury found. The jury found by clear and convincing evidence that punitive damages were warranted for this false imprisonment. There it is again. During phase 2, the jury found by clear and convincing evidence that Johns Hopkins All Children's Hospital had the specific intent to harm Maya, and in fact, did harm Maya Kowalski. The jury elected to assess $15 million in punitive damages against Johns Hopkins in favor of Maya Kowalski based on the conduct in the claim. As to claim 1B, false imprisonment for October 18th to 20th, the jury awarded Maya Kowalski $1.4 million in economic damages subsequent to her being 18, and they awarded $3 million in non-economic damages. They also awarded Jack Kowalski individually $561,300-ish in economic damages associated with the expenses of hospitalization and medical, psychological, and nursing care and treatment for the benefit of Maya in the past and through the date she reached 18. As to claim 1B, the jury found clear and convincing evidence that punitive damages were warranted for the false imprisonment. Don't know how many times you can say it. There was false imprisonment. During phase 2, the jury found by clear and convincing evidence that Johns Hopkins All Children's Hospital had the specific intent to harm Maya, and in fact did harm Maya. They elected to assess $10 million in punitive damages. The false imprisonment from January 6th. On January 6th, the jury awarded $188,000 in economic damages and $15 million in non-economic damages. They awarded Jack $325,000 in economic damages associated with the expenses. And also the jury found that the punitive damages were warranted and that they had been damaged. To see here, is it okay? The court consolidated the verdict form, the punitive damage matters for claim 1C and 2A, as it involved the same photo session. In claim 2A, battery. In the battery claims, the jury awarded Maya $4 million in economic damages, subsequent to her being 18, and awarded $8 million in non-economic damages. The jury awarded Jack individually $559,000 in economic damages. Also, they found clear and convincing evidence that punitive damages were warranted for the battery. Both claims related to the photo session. The jury found by clear and convincing evidence that JHACH had the specific intent to harm Maya Kowalski. They intended to harm her, and in fact, they did harm Maya Kowalski. The jury elected to assess $25 million in punitive damages. Claim 2, the battery of hugs, pats, kisses, and placing on lap. That's creepy. That's just disgusting and creepy. Count 5 of the operative complaint. The jury awarded Maya Kowalski $8 million in economic damages and $11 in non-economic damages. They awarded Jack Kowalski $1,000. Claim 3, medical negligence. Maya got $4.7 million in economic damages and $22 million in non-economic damages. The jury also found as fact that Dr. Sally Smith was the apparent agent of defendant Johns Hopkins All Children's Hospital, and that Dr. Sally Smith's negligence was a legal cause of loss, injury, or damage to Maya Kowalski. As to claim 4, fraudulent billing, the jury awarded individually $5 million in economic damages. Claim 5, intentional infliction of emotional distress against Beata Kowalski. The jury awarded Jack $3 million for non-economic damages associated with Beata Kowalski's pain and suffering and mental anguish. As to claim 6, wrongful death for intentional infliction of emotional distress. The jury awarded $653,676 for loss of accumulations, awarded Jack surviving spouse $18 million for loss of support and services, and $50 million in loss for his wife's companionship and protection. As remitted by the court to $24 million. The jury awarded Maya Kowalski survivor damages of $2 million for loss of support and services, remitted to $1.75 million, and $18 million for loss of parental companionship, instruction, and guidance, the pain and suffering. The jury awarded Kyle Kowalski $2 million. The court remitted it to $1.75 million and $18 million for loss of parental companionship, instruction, guidance, and pain and suffering. Claim 7. Intentional infliction of emotional distress, Maya Kowalski. The operative complaint. The jury awarded Maya Kowalski $3 million in economic damages. The jury awarded her $7.5 in non-economic damages. Whew. That took a while to get through. Now, it's adjudged. This is the judgment here in the last couple pages. Then we're done. We're done with the first instance court proceedings, and it'll be a long time probably. Well, the next thing we'll hear about is the sanctions motions. But other than that, it'll be a long time before we hear about this again in court. If there are any big major developments, we'll look at them. So it is based on all of that stuff above. It is judged. Boy, my mouth is going numb here. It is adjudged. Plaintiff Maya Kowalski individually shall recover from defendant Johns Hopkins All Children's Hospital, a Florida not-for-profit corporation whose address is this, a compensatory damages in the amount of $93,284,000, less $2.5 million for set-off as stipulated by the parties due to a prior settlement. That was due to the prior settlement relating to Beatty, I believe. I can't forget. It was Beatty that had the. Was it Beatty or Sally that had the $2.5 million settlement against her? I think it was Beatty. That's what they're talking about there. They already got paid that $2.5 million, so it gets set off. And punitive damages in the amount of $50, making Sally Smith. That's right. That's what I thought. I second guessed myself and said wrong. It was Suncoast, yeah. Suncoast settled for $2.5 million, and so they deducted that from the total damages. So 93.284 less 2.5, and the punitive damages for $50 million, making the total judgment $140,784,000, which shall bear interest at the rate of 9% per year. That's pretty steep. That's 14 mil a year-ish, just slightly under 14 mil a year. And this is going to go on for more years. For the balance of 2024 and thereafter adjusted annually in January 1st with the interest rate then in effect determined by the CFO of the state of Florida. Plaintiff Jack Kowalski. So Maya gets $140.784 million. Jack Kowalski, he gets $1,513,500. Same interest rate. Jack Kowalski, he gets $66,153,676. Same interest rate. Within 45 days, Johns Hopkins All Children's Hospital shall complete and execute under oath or affirmative Florida Civil Rule of Procedure fact information sheet and return it to plaintiff's attorney without filing the form with the clerk of court unless the judgment is satisfied. The court stays post-judgment discovery on judgment debtor of judgment debtor, or sorry, my eyes are going fuzzy, or judgment debtor posts a qualifying supersedes bond. And that's so basically, if they want to continue with this and not pay this money right now, they got 45 days to pay it, or if not, they have to put up an $8 million bond. I believe that's what Greg said it was. I believe he said it was an $8 million bond. The court reserves jurisdiction to enter further orders that are proper to address execution, post-judgment discovery, completion of the fact information sheet, and requiring judgment debtor to submit to depositions in aid of execution. Don't stroke out, Jeff. I'm trying not to. I'm trying not to. The court reserves jurisdiction to award attorney's fees or other costs or both, if any, upon a timely and successful motion. That he's already ordered them to come to some discussion and agree on court fees and lawyers' fees, or he'll do it himself. There's the mandatory mediation thing they have to go through. The court reserves jurisdiction, as discussed in the court's January 16th, 2024 order, entitled Order Concerning Outstanding Sanction Requests, to consider, address, and resolve all currently pending unresolved motions seeking any type of sanctions or against any party or attorney or both, including any matter in which the court previously awarded an entitlement to sanctions but has not yet finalized the sanctions award, all of which survives this final judgment. So we'll still get to hear about the sanctions later. What, if any, sanctions will be handed down? The court also reserves jurisdiction to address all matters associated with the court's January 16th order, entitled Order Directing Mandatory In-Person Mediation, which survives the final judgment. That, ladies and gentlemen, is, in fact, the final judgment. That's it. That's the end. I said the last thing to wrap up are lawyers' fees and sanctions. Then it will be off to the appellate court. Well, that was rough, and I came into this late. I started working on this late because we were involved with other hearings. So there's 707 of you here now, 618 likes. We closed the gap a little bit. That's great. Let's see how we did on our poll here. Unfortunately, I don't think we didn't get any of our hopes and desires for today. The like and subscribe poll, by the way, hit the like button, hit the subscribe button. And if you are subscribed, just double check to make sure you're still subscribed. We currently have 899 subscribers. If you haven't subscribed, please subscribe. That would be awesome. Let's get us up to at least 66,900. I'd love it if 100 of you weren't subscribed and we got up to like 67,000. That's my new goal. My new goal that I'm pushing for is 67,000 subscribers. We're 101 away from that. We can do that easily. Let's see. The like and subscribe poll. What are you hoping to hear from the final group of orders? 35% of you said Dracula. Sorry, there was no Dracula. 19% of you said you hope to hear about Nuremberg. Unfortunately, there was no Nuremberg. 16% of you hope to hear the word palpable. Unfortunately, there were no uses of the word palpable. And 30% of you hope to hear about the island of hair, the tuft of justice, the whatever you want to call it. There was no reference to that. It was a wash all the way across the board. Everybody leaves disappointed. Bislam says, legal advice, what happens if JHACH doesn't pay, even if the appellate court affirms? Well, then you say, we have this judgment. We are now selling your hospital. You attach their assets, you sell their assets at auction. So yeah, you basically walk in and you put a big red sticker on the outside of the hospital and say, we're selling the hospital at auction to pay your debts. You attach bank accounts, you garnish everything they get. They'll get their money. Once this is finalized forever and ever and ever, they'll get their money. All right, now for the remaining 676, what do we got here? We got only 2 minutes until I normally shut down, but we're going to go just a little bit extra today because I have an unboxing to do, an impromptu unboxing because Smopo Vienna is here. And Smopo Vienna, I've been waiting for an appearance for the past week or so. This is legit going to take me a long time. It's just right in the next room on the kitchen table, but with the super amazing acute tendonitis I have in both feet, it's going to take me a bit to one arm crutch on over there. Don't go anywhere. We'll see if we can beat the video back, the extended introduction outro video. We'll put that on as serving its purpose as I'm stepping away for a minute. 2 minutes and 51 seconds. Let's see if I can go about 10 meters in 2 minutes and 51 seconds. This hurts. All right, see you soon. Don't go anywhere. Stand by for unboxing. Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest.
Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Mauryan Empire or whatever, bitch. Because they're so fucking absurd. If you want to be a sovereign
Okay. Oh God, that just takes it out of me. Just moving is just an exhausting thing. Now, okay. Smopo Vienna sent a package, and we're working on getting one of Joe Choi has also sent some stuff, and we're working on that getting here. So we're still working on that getting here, but right now we've got this box from Smopo Vienna, and they certainly did a number on is amazing, wonderful box, but it sort of the box sort of came completely unassembled, like. They did a number on the box, and it was inside of a bag, so it just kind of collapsed about itself. But the first thing about Smopo Vienna's box here is there's this really cool laser engraved cover on the top of the box. So yeah, there we go, and I'm trying to find a way to get this duct tape off so it doesn't doesn't take the edge off the wood. I might just have to cut across the wood here with like a bandsaw, but that's like way cool. So that's the top of the box. I'll keep the top of the box and put that somewhere. So yeah, it's even got a cool box. And then there was a very, very nice letter from Smopo Vienna in there, which I read, and I deeply appreciate it. And tell your father thank you as well. All right. Now, for the first time, I'm seeing this. Wonder what that could be protecting. All right. Oh, wow. There's lots in here. There's a beautiful ceramic, and these are all made by Smopo Vienna. A wonderful ceramic shot glass. Come on, get up there. Why are you not doing your thing? Autofocus. Autofocus. There we go. Yes, we have this lovely ceramic glazed shot glass. That's beautiful. Wow. Thank you. We'll definitely be using that. And here's a very, very nice mug to go with the same concept, the same design here. The coffee mug. Let's see if we can get that in focus there. Smoked pottery. That's their brand, the smoked pottery. That's like really cool. There's a good coffee mug. Well, we can definitely use a coffee mug here. Thank you so much for that. That is like way cool. No, it's just a normal shot glass. Unfortunately, my hands are quite average size. And what? Well, this is kind of cool. We got the smoked pottery business card here. You should throw down some links, Smopo. So we got this here. See, now we know where Smopo comes from. Smoked pottery. Smoked pottery. And they're in Vienna. I get it now. It's Smopo Vienna for smoked pottery in Vienna. It all makes sense now. There's the let's see, zoom. The smoked pottery. I'll put that here so I remind myself to put it in the description down below. And there's one, I didn't, this is another coffee mug. Ashley Casey, thank you so much for the $5 super chat. We super chat. We love super chats. Thank you so much for the super chat. Jeff, where did you get that hat? I must have one. This is from Flux. This is from our very own House of Flux, proprietor of the House of Flux channel, who's here she's one of our mods. She has her own YouTube channel, House of Flux. This is her hat. She gave it to me when we were in Houston last August for Anime Matsuri. I'm keeping it. I'm keeping it for her until she asks for. I'm caretaking the hat until she asks for it back. It's a custom made job. She made it herself. So yeah, this is another coffee cup that's like way cool. It's got a skull on it. Come on, skull. Got a cracked skull on it. And the handle is like half of a ship's anchor. That's way cool. So yeah, just like an anchor is like dug into the back of the skull. I like that. Flux says, "Lol, it's Jeff's hat now." No, I'm only keeping this hat until you ask for it back. So that's cool. I like that. It's got like the half of the anchor. So if you sit like that, you can see it's like half of an anchor. That's dang cool. So now I've got two more coffee cups and another shot glass, which I'll put over there in my liquor cabinet. But this is cool. This is cool. Oh my God, this weighs a ton. This is a ceramic pipe. When he said he was making this face hugger pipe, I was expecting something about a third this size. This is an enormous, this is like a weapon. This is way cool. This is a ceramic face hugger pipe. Let's see if we can get, yeah. It's like the face hugger is coiled around the front of the pipe. Oop, nah. There you go. So yeah, got the face hugger coiling around the pipe. It's got the pipe stem, and this has a huge bowl. Well, I will definitely. I'll give this a try tomorrow. I'll put this next to my other alien pipe, and I will give this a shot tomorrow. I will smoke it on stream tomorrow to see if it works. But let's give it a test. Okay. Gets air through there. It does its job. That's what it's supposed to do. Wow. That's really cool. Thank you so much for that. That's awesome. I got Presties. Thank you so much. And with any luck, we should have Joe Choi's on the way by the end of this week. And it should take, so we should have Joe Choi's box that is taken forever to get sent from the UK here by next week. So hopefully we'll so. And if we do, we'll do another unboxing next week. Right. That is super awesome. And thank you so much for that, Smopo. That is like way cool. Now you're amazing. I'm not amazing. We're not amazing. You are. You're amazing. Thank you so much for those handcrafted gifts. And these coffee mugs are. See, I want to take these to my office, but coffee mugs have this bizarre way of getting broken, especially if I like them in the office. To this day, I'm like in 30 years of working for this firm, nothing makes me angrier than thinking I went to the Stanley Hotel. It was the hotel where Stephen King stayed and had all the weird, scary experiences that made him write The Shining. And I got a coffee mug from there, black coffee mug that in red letters says Red Rum on it. Somebody in my office broke that, and they just pretended like it didn't happen. Nobody knows. Nobody's seen it. Asked everybody in the office. Nobody has a clue what happened to my Red Rum coffee mug. I had this big blue Tigger coffee mug that I loved. I got it from Disneyland because I'm a huge Tigger fan. That got mistakenly broken. Nobody knows what happened to that. So anything I like, I don't put in the office anymore. I've learned my lesson. But so these will stay here at the home. And they will be making appearances on stream. Oh, these are so awesome. Thank you so much. All right, everybody. I guess that's kind of it. Aw. Thank you. All right. Well, here's what's coming up. Thank you. There's still 545 of you here, and we've got up to 66,902 subscribers. We're 98 away from hitting 67,000. I think we should do a 24-hour stream. I know I was supposed to do a 24-hour stream for my 50,000, but we never got there. We should do that. We should do that if we hit 67,000. All right, here's what's coming up for the rest of the week. Tomorrow, Flux, Lamau, that's a weed pipe. Good deep bowls, lol. This bowl is so big that if you put weed in there, it would probably kill you. I mean, it's like that deep. And it's I like big balls. I've got big balls. He's got big balls. I've got the biggest balls of them all. Right. Yeah. I like big bowls on my tobacco pipes because I get to smoke them for a long time. Here's what's coming up. Here's what's tomorrow. We're going to be doing the Jane Clayton Eckert. I got 2 blowjobs and she says she's pregnant with twins case. We've got more. She was supposed to undergo a deposition last week. She just ghosted the court, just said, I ain't coming. She just didn't show up for you just can't do that. So that we're going to be talking about that, her reasons why she doesn't want to go to the jurisdiction, to the deposition, which surprisingly are, surprise. Just a second here. Surprisingly, her reasons are she wants the deposition to be private and sealed, which ain't gonna happen. So we're gonna read that motion that she submitted. We're gonna be looking at an exchange of emails between her lawyers, which is hilarious. Even her own lawyers is like, yeah, I'm in a shitty case. Her lawyer is hilarious in this. And then we're gonna go back and we're gonna look at some of the other evidence that we haven't looked at yet. All the crazy articles she's written, all the, some of the 500 texts she sent. We're going to just fill 2 hours with Jane and Clayton Eckert case. We're going to dispel the mouth conceptions in that case, as we're calling it. The mouth conceptions about tonsil twins. And Ashley Casey, I already answered that. I don't know why I brought that back up. Thank you very much. A mistaken super chat. I thought we had another super chat. We don't. What I meant to click on was Kelly Wall. Jeff, don't start that information because I will line up to disprove that too much weed trope. Line up. All right. So Tuesday, tomorrow is Jane Doe and Clayton Eckert. Wednesday, we are going to be looking at the Zachariah Anderson police interrogation video. Finally, that's been released. We finally have the entire police interrogation video, and we'll do Sadie's when that's available. But Wednesday we'll be breaking down the Zachariah Anderson police interrogation video. Thursday will be O.J. Simpson. We're continuing with the closing arguments with Johnny Cochran, and Friday we will be looking at the Aguilar Mendez case, the 18-year-old Guatemalan who was brutally beaten by cops because he couldn't speak English. And they didn't like the cut of his jib, whatever. And he's been charged with manslaughter because after 5'4", 115-pound, 18-year-old boy was jumped on by 4 massive cops, tased 6 or 7 times, put in handcuffs, and minutes later, the first officer on scene keels over and dies. So they've charged him with aggravated manslaughter. Although the autopsy report showed the cop had arrhythmic heartbeat, hardening of the arteries, high blood pressure, bronchitis, and a bunch of other shit going on. So we're gonna talk more about that. There was a bond motion. We might have a motion to dismiss at some point in the future, but we're gonna definitely be looking at the bond motion and any other news to update on that. That's what's coming up for the rest of this week. So, okay, folks, let me find a place to send you because I am going to go relax on my bed with my feet elevated and an ice pack on my feet to try to reduce the swelling so I don't want to die. Again, the doctor said I probably have 2 weeks of sheer hell to get through before my pain in my feet go away. So I'm not looking forward to another 8 or 9 days of this. It's aggravating. Right. Content. Let's go to today's live show. Where are we gonna get sent to? Let's see. While I'm doing this, I just want to say thanks, mods, for being here, for doing all of your moddy things. Chat, thank you for being here. All of you are the greatest chat on the entire internet. Hands down, no questions asked. The Vice Squad rules. I really wish I could multitask because every time I talk, I stop typing, and every time I type, I stop talking. All right, redirect. And thank you so much for the generosity, the super chats that came in, and Smopo Vienna, thank you so much for your handmade gifts. I will be definitely trying all of them out over the next few days. We'll let you know how it goes. And after going through all of that, looks like we've got live Danny on direct. Let's go over to Danny on direct, everybody. She's doing the missing mom trial, day 7. Let's all go say hi to Danny on. Tell her Legal Vices sent you, and tell her hi, and make sure you like and subscribe to her. Let's do it right now. Thank you again, everybody. Law Racks out. See you tomorrow.